Isaac?
Hi, Julian.
Hi, good evening.
Evening. Yeah. Hi. Just hang on for a few minutes. I'm sure more people are going to join us. So just hang on for like 5 minutes or so. Okay, everybody. Is our last class. I believe you guys are writing exams like in this week. Is that correct?
Yes, that's correct.
On Thursday.
We are writing on the 18th. It's a portfolio. So
Okay.
18 to Wednesday, Thursday.
Right. So I mean, it's not all that bad, eh? I mean, it's you get to take your paper, you get to answer your paper on your own terms. You've got 24 hours to do it. And we've covered quite a bit. The last time we stopped at unfair dismissals, and we looked at, we discussed unfair dismissals quite in depth, you know, substantive and procedural fairness, and what is substantive fairness, and what is procedural fairness, misconduct, incapacity, operational requirements, and we discussed them all in detail. As everybody, and we went through operational requirements, I believe, in our last session. Is there anything further, or any aspect that you guys would like me to touch upon this evening? Before I take out another, test paper, we can go through another question from another institution, also dealing with the work. Okay, if not, yes, Lizzie.
I just wanted to say nothing from my side.
Okay. Okay, then anybody else? No? All right, let's just move on to an exercise. Okay. Can you all see that? I've shared my screen. Can you all see that?
Your screen is blank. It's just showing your name.
Really? Okay, let me go back there again. Still nothing,
Yes.
huh?
Yeah, I can see now. Thank you.
Anybody else? Everybody else, can you see it? Hey?
Yes, I can see.
Jillian and Fatima, can you see it? Queen, can you see it?
Yes, sir.
Okay.
Can you zoom in a bit? I can see, but it's a bit far.
Yeah, okay. What I can do is I can try and make the screen a bit bigger, the viewing field. Oh.
Sir,
Yeah.
if you look at the bottom of your page, there is like a minus and then there we go. Yeah.
Okay. So tell me if this is big enough. How's that?
That's perfect.
Is that okay? Okay, good. So let's do this little exercise. Thomas is a single electrician at a company that specializes in the installation of light fixtures. One day, Tom is electrocuted while installing a light fixture. Although he is
Your network is bad. You are breaking
seriously, he
off.
will have his medical. Is it bad? Breaking up. Hey.
You're breaking up a lot.
Okay, 1 second. Okay. Is it better? How does it sound now?
Clear. Thank you.
Much better, eh? Good. So, okay, read this, guys. So this is about Thomas, who gets hurt while working, and his medical aid will cover the cost of his stay in hospital. He's still worried about the fact that he won't be earning a salary to provide for his children at home. Do you think Thomas's employer has the responsibility to provide his employees with access to a fund to provide for incapacity due to illness or injury at work?
Yes.
Okay. Now the question now becomes, that's just a simple thing, but like, can every employer actually afford to do that?
No.
So these are our questions. So we all feel strongly that, in this scenario, that the employer should have a fund that should help the employers, when they become ill or get injured at work. That would be very good. And do you guys know of any employers that have such funds, that the employer offers such a thing? Okay, you don't? Any of you work for the state? Well, if you work for the state, you'll know the state as the employer has got insurances and things like that, and funds that they take from your salary to invest on your behalf, to a fund like that. But in the absence of such a fund, do you think that the state should provide Thomas with access to a fund to provide for his family when he is unable to work? So if there's no such fund, do you think that the state should provide Thomas with access to such a fund to provide for his family when he's able to work? What do you think?
I think they should be able to.
Mm-hmm.
They should be able to cover if it's temporary illness and stuff. But where does the whole UIF and COIDA come in? Isn't that where the funds should be accessed, like through those two?
Mm-hmm. Good point, yeah. So UIF and COIDA, both type of insurance funds, but they've got different objectives. The unemployment insurance fund is, how does that work? That is where 1% of your salary gets deducted and paid over to the Department of Labor. And when you are unemployed, you can now claim for a short period. And a short periods means, a few months or so, while you're looking for other work, to get you through that time. So this is when you claim unemployment insurance, or you claim from that fund to help you through that difficulty. And that is the objective of that fund. Now, you mentioned something else, COIDA. What is COIDA about?
That's the fund for injury on duty. Most employers are supposed to contribute towards that. So, like in the case of Thomas, he was electrocuted while he was at work, so that he should be able to claim through that for temporary incapacity.
All right, good. So this is the answer to the question, yes, that the question is, in the absence of such a fund that the employer should have, shouldn't the state provide such a fund? And the state does provide such a fund known as the Compensation for Occupational Injuries and Diseases Act, in terms of which the Workmen's Compensation Fund is created, and there's a commission of that fund as well who administered that fund. And just like UIF, where money gets deducted from your salary, in the same way money also gets deducted by your employer from your salary for this fund. And this is to cover you in cases like this. So what do you think you'll be able to claim? Who knows what one is entitled to claim from COIDA, from the commission, from the Workmen's Compensation Fund? What would Thomas be able to get out of this? So he can get his medical aid, his medical bills covered. He could get, his loss of income, his loss of support, and he's unable to provide for his family like he was before. You could get future medicals as well, paid for through this fund. Okay, so the fund is there to help, and it's just a question of how you claim. But this is often been criticized as one of the sleepiest departments under the Department of Labor. They take a long time to process claims, and it's quite a process. If anybody's been involved in this, they know it's quite a process. You have to get medical records, you have to have a first report, you have to come back for an assessment. There's further things that you must submit to be able to get all your to claim for your losses and your damages. So all of this is basically examples of what we call social security legislation. Okay, there are other funds as well, like for example the Road Accident Fund Act. Do you know how that works? This is where the state. So this is something people don't actually. Many people overlook it, or they're quick to criticize the government, but in reality, there are funds available to people who find themselves in situations like this. So I spoke about the Road Accident Fund. Has anybody got any clue what that is about? It's unrelated to this, but it's nonetheless an example of social security legislation.
Is somebody else open? Okay, I know this one. It's where people claim after being in an accident on the public road. So I know that people can claim after being in accidents on public roads.
Yes, it doesn't even have to be a public road, but I mean, it's any injury or death that is sustained, injuries that you've sustained or death that has resulted and arising from the negligent driving of a motor vehicle. Okay, so who pays for it? How does this get paid? Like in the UIF and the COIDA claims, it gets deducted from your salary. But now, who pays for your damages that you suffer there? If you're going to say the Road Accident Fund, yes, the Road Accident Fund is merely the agency responsible for administering these claims. But at the end of the day, where do they get the money from? Okay, so this money comes from the fuel levy. Okay, what does fuel cost per liter? Fuel is like 14 rand, 13, 14, 15 rand a liter. So a portion of those, for every liter, a few rands go towards this fund. Okay, and it will ensure from when they incur or sustain damages or suffering or pain or even death. Like, I mean, if your breadwinner, if it's a husband that dies in a motor vehicle accident and he leaves behind a wife and children, they can claim from the fund that, the breadwinner, if he was, is now died and we've lost, and they can claim, and that's another subject on its own. Okay. So all of these social security legislation takes the burden off certain parties, and the state kind of takes on this. If you were to be injured at work, you could technically hold your employer under normal laws of delict. You'd have to sue your employer for that. And COIDA says, no, you shouldn't sue your employer. You should take claim from this fund, your injuries. Okay, so for your general injuries and your medical bills and so on, and your losses, you can claim from the fund. But there is an exception also within that Compensation for Occupational Injuries and Diseases Act, that if the employer was grossly negligent, that over and above this claim, you can also look to the employer for the balance. If the fund doesn't pay everything, especially, turn to the employer in very limited instances. Okay. Okay, any further questions on this? No? I want to move on to another exercise. Where are we now? Okay, can we all see that?
Yes, thank you.
Is it clear? Okay, good.
Can I go a bit bigger, please?
A bit bigger. Okay. How's
So
that?
just click on the plus button. It's a lot easier to manage.
Yeah, is that better now? I just did that.
A bit bigger.
A bit. Can you read it at least? Can you see it?
Yes. Now I can.
Oh, okay. Okay, fine. Okay. Sipho and Simon work for the same company and have both recently graduated with degrees in business administration from the same university. On their first day at work, they were told that they are both on a junior level and they report to the same line manager. A few months after they started working, Simon was given a laptop, petrol card, and a company car. He was also moved into a private office and told he can report directly to the owner of the company. Sipho still shares a cubicle with two interns who are job shadowing and has not been given the same benefits as Simon. Do you think that the different treatment for Simon and Sipho is allowed by the law in South Africa? Okay, what subject area are we doing or are we dealing with now? Hello?
Is that maybe an unfair labor practice?
That is the, okay, unfair labor practice. You're going to have to justify that, but now it's possible. It's not completely impossible. Is it unjust? Is it unfair labor practice? Okay, let us look at section 186, subsection 2 of the LRA. And that describes what an unfair labor practice is, right? It is any conduct or any omission on the part of the employer which is unfair, and it's relating to promotion, demotion, training, receiving benefits, probation, and even suspension. So my question here is this unfair labor practice or is this unlawful discrimination? And how will we know that?
Can it be both?
Now, it quite can sometimes be depending on what one can prove, you know.
Yes.
You know, the thing is, what's her name? You know, Gillian, you raised it, you know, that could it be, Gillian believes it could be unfair labor practice, I think. But is it unlawful discrimination? So it relates to what one can prove, what one can show. Okay?
I will go with the discrimination. Reason being,
You mean unlawful discrimination?
I'll say unlawful discrimination.
Okay.
And then I'll explain it in the sense of when you touch on the whole equal pay, equal work. So do they have a justifiable reason for the differences in the benefits if we all both hold the same degrees and stuff? Okay. So I think Sipho will have a claim if they cannot justify why someone has got extra benefits.
So now, let us look at these questions now. You know, let us ask ourselves to answer, get ourselves to answer the questions. This different treatment of Simon and Sipho, is it allowed by the law in South Africa? Interesting question. Can you treat one person? Okay, can I, if you employ these two guys, Simon and Sipho, and you give Simon a laptop, a petrol card, and a company car, do you think, I mean, are you entitled to do that as an employer? While the other guy is just in a cubicle. Because there's a particular word that you must explain here. But the question is, it's nice. The question is interesting. Do you think that the different treatment of these two are allowed by law? So whatever you say, I think if you agree or if you disagree, you're going to have to say why. So there's a legal term when you deal with the Employment Equity Act as well. It's called differentiation. There's two terms, differentiation and discrimination. Even discrimination is not necessarily wrong. It is unlawful discrimination that is against to discriminate and to differentiate between people for various reasons. Maybe why was Simon given a laptop, petrol card, and company car? Why was he given all these benefits? If it was done, the employer's got some kind of discretion in awarding benefits and things. But if Simon was doing very well at his job compared to Sipho and was excelling and was therefore given these things as a reward, would it still be wrong? It will be hard to say that, right? So we must firstly differentiate or distinguish between rather those two terms. Differentiation, it's where people, we look at the individual characteristics of a person to distinguish that person from somebody else, right? Because the Employment Equity Act, what is the goal of the Employment Equity Act? It is to create equity in the workplace. People get fair opportunities on the one hand, and on the other hand, the employer must also be given the choice, right? If we say we're going to reward people who do well, it therefore becomes, and somebody does do well, and the other person doesn't do well, then the employer is obliged now to differentiate between those. Okay, and differentiation therefore is not unlawful. It is when the section 1861 dealing with unfair labor practices, on the other hand, says that when there's an unfairness, on the part of the employer in the way that he treats the employees, regarding promotion. So there's various grounds and various for each of these things: promotion, demotion, probation, training, benefits, suspension, etc. All of them have to be investigated on their own merits. Okay. Now, what is the core difference between unfair labor practices and unlawful discrimination? Okay, remember when we came to discrimination, then one has to these grounds of discrimination. In fact, there are listed grounds. Can you recall those? Remember? What are those? The Employment Equity Act mentions them. Section 8 and Section 8 of the Constitution mentions them. The Labor Relations Act, Section 187, when it deals with automatically unfair dismissals. Okay, and automatically unfair. Yes. Someone was saying something? Nope. Okay. Section 187 that deals with unlawful or with automatically unfair dismissal lists. unlawful discrimination as an automatically unfair dismissal. Okay, the employer has dismissed somebody for unlawfully discriminating against them on those listed grounds. Right? Can you just think back now? What are those listed grounds?
We've got
The
race,
number of them. Race,
gender, sex, disability.
Yes, it goes on. There's quite a list there. It's like 17 grounds. Okay, so that is a listed ground. So when you coming back to the question of whether this is an unlawful discrimination matter or an unfair labor practice matter, unlawful discrimination requires you to base your claim of unlawful discrimination on one of those grounds. But that is only half the story. Can you also base your claim on an arbitrary ground? In other words, it's a discrimination based not on one of those listed grounds.
Yes, you can.
Yes.
I think we touched. Yeah, and then the onus is on the employee.
Good.
Yes.
Very good. So that is an influence on the onus now. Okay, to prove, because once you make that allegation, well, they discriminated against me because of my religion. All right. Then the onus to prove that this is unfair or fair rather would move on to the employer. But once you claim it on an unlisted ground, you simply say, well, this is unlawful discrimination, but you don't specify what. Then the onus would move more onto you, the employee, who's making the claim of unlawful discrimination. Okay. What do you think are the reasons why the employer treats Sipho and Simon differently? I touched on this, but I'd like to hear you guys also give me your input. Why do you think they treat Sipho and Simon differently? Hey? Think about it. I mean, I did mention something, but I just want to see if you guys can recall that as well. Why do you think the one person gets all these things and the other doesn't? Why do you think?
The one thing that you touched on was on performance. You said he might be getting all that based on purely on performance. If he's performing better during his probation, then he's getting all those as incentives and rewards. They are all rewards in a sense.
So reasonably, we could expect that to be the case. In fact, we are hoping that that's the case, right? That it's because the person has done something extraordinary. He has performed well, and therefore he is being treated so favorably. Now, the next question is interesting. Do you think there should be mechanisms in place to ensure that Sipho gets the same treatment as Simon? Yes. Do you think there should be mechanisms in place that the one gets the same chances as the other?
I'm just gonna try on this one.
Well, we already have the scum, Jillian and Queen and Fatima. What do you think? I mean, it's a no-brainer, this one. I mean, like, if you consider fairness as the primary, goal in everything that we deal with here, right? Fairness. So there should be mechanisms in place, right? Don't you all agree that at least Sipho and Simon and whoever else, Michael, whoever's in that same category, all get the same chance, the same treatment? Right. Yes. Now, my next question to you guys is, how can they ensure What kind of mechanisms are there to be put in place to ensure that Sipo and Michael and Leonard and whoever else gets the same treatment that Simon gets? What could an employer do, and what must an employer do, actually?
I think one of the mechanisms which employers can probably use, besides having like a policy in place, okay, you should have, they should have policies in place, but I think the enforcement of the policies is usually the problem.
Yes, the interpretation and the consequent enforcement. But the main thing is, yes, you must have a policy in place. I've said this many times. An employer must have a policy on every aspect, basically, in the workplace. Right? Unfair dismissals, it must have a policy. It should tell us, like, what is it should spell out for the workers, look, this is not acceptable conduct. Here's the disciplinary code. Here's the process that we follow. These are considered to be the offenses. Okay. Promotion. We move on from there. How about promotion? This is how we promote people. Right? In fact, this at employee level, right, is so important because even at management level and shareholder level, which is a big deal in the corporate world today, about how, for example, how executives must be remunerated, how they must be paid. It's become such a bone of contention in corporate entities, the large corporate entities today. And there's guidelines on this, there's like what they call the King Code on corporate governance, King 4. There's been a King 1, 2, and 3, which that is like the guidelines that they put out and say, look, for the directors and the board to receive bonuses, the board can't decide how they must be remunerated. This must be given to another independent committee, for example. Okay, so all these methods and things, but comes down to the central point, which is that there must be a policy that becomes the rule in the workplace. Okay, so that all others know, okay, why did this guy get all these things? A car, company car, a cell phone, and petrol allowance, whatever. Why did he get it? And then when there is a violation of that policy, then one can now determine whether one has been unlawfully discriminated against, number one, or whether it constitutes, as you raised, Gillian, an unfair labor practice. Okay. Now, I'll tell you something. I might have mentioned it to you before. I'm sitting with a case where I have the exact same problem, where I'm unsure. Well, I'm not unsure, but I mean, I'm going to use buckles and braces. Buckles and braces to keep your pants up. You use a belt buckle and braces. I'm going to use both to make sure that I don't miss, because this client is a female and she's got a particular condition, appearance has been affected due to some skin disorder, and she's been employed for, I think, 9 years with this company, and she has been overlooked for promotion and for furtherance and for increases for a long time. And when I listen to a story, it has elements of both an unlawful discrimination referral as well as unfair labor practice elements. And if you fill in the CCMA referral form, it actually makes provision for an unlawful discrimination matter as well as an unfair labor practice matter, which you refer the matter as. Okay, but central to me making my decision as to whether it is unlawful discrimination referral or an unfair labor practice was for me to get the employer's policy. And this is where I have been now for the last few weeks. The employer just does not want to provide this policy. And why do you think that is? We're about to now launch other court proceedings or rely on other mechanisms, obtain the policy. It shouldn't be this hard. A policy should be publicly displayed and easily available to all employees. Not publicly displayed. It could be. It's always good, you know, for a company to have that kind of behavior so that everybody knows how they operate, and especially the larger companies who want to be good corporate citizens and good employers, in fact, do that, you know. You can get the appointment policy, the interview policy, the sexual harassment policy, the policies on all kinds of things, including this promotions and demotions from the employer. But now, why do you think the employers are giving us such a hard time? We're demanding it and we're demanding it, and they are not coming forward to give it to us. What do you think would be the reason? Well, the reason could be one of two things: that either they realize that the policy that they do have will show that they are in the wrong, and that they've either been unfairly treating her, or that they've unlawfully discriminated against her, or secondly, they may not even have a policy. Okay, that's also not so surprising with some companies and some employers, that they don't have that policy. And what happens now, guys, in the event that an employer doesn't have a policy in place? Just think about it as it relates to all aspects of labor law. If it's an unfair dismissal, if it is, unfair promotion or demotion, if it is harassment in the workplace, whether it is privacy policy, whether it is policies on many things. So what happens in such a case where an employer doesn't actually have a policy in place? What then happens? And the matter goes to the CCMA. Let's assume that it is an unfair labor practice, Gillian. Let's start there. She refers it. All right, and she's going to say it's unfair. But now unfair can only be measured by a certain standard. The standard isn't being made available because there's no policy in place. What happens in such a case? Then the courts, or the CCMA as it is, will read in fairness, okay, and will compare to the law, or what the law considers fair of a reasonable employer in such a case. And will have regard to many other things like the Labor Relations Act. The Labor Relations Act itself makes reference to the World Labor Organization's conventions and treaties, and how it gives guidelines on various things. So it will read in those guidelines. It will interpret what should have happened according to those guidelines. Okay. So coming back to the question, there should definitely be mechanisms in place, and as you said, there should be policies. So this will ensure that SIPO gets the same treatment as Simon. So do you think the fact that SIPO and Simon come from different racial backgrounds has a role to play in terms of the way that they get treated differently by their employer? Why or why not? Nice question. Do you think the fact that SIPO and Simon come from different racial backgrounds has a role to play in terms of the way they get treated differently by the employer? Why or why not? Hey guys, should the racial thing be playing any part in it?
Most of the time, yes.
No, but now, okay, now this is where you guys must be able to explain it, because it is not straightforward in that way. It's a bit, you must understand the turns in it, right? So race shouldn't normally be part, because one cannot. It's a listed ground of discrimination, right? If you giving him treatment better than me because he's whatever he is, whatever race the person may be, then, and if that is, then it carries grave consequences, right? And it would therefore be an unlawful discrimination matter and not an unfair labor practice matter, right? An unfair labor practice is any unfair conduct on the part of the employer, any act or omission that is unfair towards the employer relating to promotion, demotion, and the others, as I mentioned, right? But if race has been proved, is the motivating factor, it would, on the face of it, be wrong. It shouldn't be play a point. But there are exceptions. There are exceptions. What are those exceptions? Affirmative action is the exception, because affirmative action says discrimination isn't normally allowed on race especially, but to achieve, to address the historical unfairness in the workplace, we have to now, and the current unfairness that promote opportunities to the previously disadvantaged individual, and to look at them and see how
Your network, we are losing you.
we can give breaking. Okay.
You sound like your network is very bad.
Second. It's even telling me a bad network quality. I don't know why that is. Let me just see.
Much better.
Is it better now? Okay. Okay. So yes, employment. What's it? Affirmative action. All right. Could be the only justification why there would be this kind of discrimination. Okay. Which makes it lawful, which on the face of it would appear to be unlawful. And what's the other justification for discriminating against somebody that would make the discrimination lawful, so to speak? Affirmative action is the one. What is the other? Right. Remember when we speak of unlawful discrimination, not unfair labor practices, but unlawful discrimination, then the other ground is inherent requirements of the job. We call that. Sometimes the job itself requires us to discriminate in such a way that we have to appoint a person of a certain category on a certain ground to that position, right? If we are saying that, look, we want a lingerie model, okay, Victoria's Secret, you know who that is, right? I mean, they sell ladies' underwear. So now, if a man applies for the position and we say we only want women, right? Obviously, we're going to have to. That would be an inherent requirement of the job. So be mindful of that, okay? That these employment, these affirmative action and the inherent requirements of the job. It's the only grounds that you could lawfully discriminate. Any questions on that? No. Do you think the employer should introduce policies that will prevent the repeat of the ways in which employers have treated employees differently in the past?
Yes.
Clearly, right? I mean, we've now dealt with this now. I think I've dealt with that. And it's the creation of policy, and that is very important. Okay. Remember, the mark of fairness is when any CCMA arbitrator or judge will look at the existing policy and he sees, if it's an unfair dismissal, if it's an unfair labor practice, if it's an unlawful discrimination matter, they look at existing policy and the first question they ask is, okay, is there a policy in place? Yes. Did the employer apply the policy fairly? If the employer has not applied the policy to the employee, then it's unfair. Okay. Now, there's two things that raise here. What happens if the policy itself, there is a policy, but the policy is also unfair? The rule is a bit unfair or unreasonable. Then what?
It cannot be enforced. So if I were to take them to the CCMA, my chances of winning are high because it's not enforceable.
Good. That is basically the rule, yes, Lizzie. That an employer, let's say it's an unfair dismissal matter, the employer says, well, okay, the onus is on me to prove that the dismissal was fair. So I dismissed him for certain thing, and my policy says this, my policy says that, I applied my policy. And then the employer may be of the mind that I've not done my duty, I've shown that I had a policy and that I applied it. But if the employee takes the view that, or the employee argues now that that rule itself it's unreasonable, right? It is unreasonable, then the arbitrator or the judge may have to then apply that standard to it and to see, well, is the rule reasonable or not? Okay. And with the Bill of Rights, okay, with the spirit, purport, and object of the Bill of Rights. So this means that we live in an open and democratic society. And the courts therefore must, they can develop the law in line with the Constitution. Okay, so maybe employers have policies in place that have been there for decades, but the policy itself is archaic. It represents, thinking, and it represents rules that were like there, 30, 40 years ago, and will not withstand constitutional scrutiny. Then you can be, you can challenge it as well. Just one quick thing, I think I may have mentioned this before, but unlawful can someone explain to me and tell me now? Can it be anybody? I'd prefer an answer from Queen, Jillian, or Fatima will answer this evening. Unfair labor practices, unlawful, you refer it, where do you refer it to? Who do you refer your problem to if you believe you have a case for unfair labor practice and unlawful discrimination? Where does it get referred to?
To the CCMA?
CCMA or a bargaining council if you are an employee that falls bargaining. Now, with the unfair labor practice, you set it down for conciliation and mediation, right? And then it fails there. In other words, you guys couldn't. Then where does the unfair labor practice go to from there? Unfair labor practice. Where does it go? It couldn't be settled at conciliation or mediation. Where does it go to from there?
Arbitration.
Arbitration, yes. Okay. Right, it goes to arbitration. Unfair labor, unlawful discrimination. Okay, it gets conciliated and mediated, but it doesn't succeed there. Where does it go to from there? Does it also go to arbitration like the unfair labor practice? Yeah?
Yes.
No, it doesn't.
I guess
Yeah. It goes to the labor court from there. Okay. That is the difference between how far an unfair labor practice and an unlawful discrimination matter, goes at the CCMA or the bargaining council. The unfair labor practice will go right to arbitration at the CCMA or the bargaining council, right, as a way to resolve it. But unlawful discrimination matter, you can conciliate it, you can mediate it at CCMA level, but if it cannot be resolved there, then it goes to the labor court. And why do you think it goes to the labor court instead of being arbitrated like an unfair labor practice claim? Anybody get any thoughts about that? I'll give you a clue. Section 187 of the LRA. Section 187 deals with automatically unfair dismissals. Okay, and if you are dismissed on the ground of unlawful discrimination matters, then it will count as such. But even unlawful discrimination matters, regardless, must be resolved at the CCMA, rather at the labor court. And what makes automatically unfair dismissals different to normal dismissals?
Compensation can be up to 2 years.
There we go. Okay. So therefore, the labor court would be in a better position to exercise that discretion. It will be it will be a labor court judge, a judge for all other intents and purposes, who would now deliberate and decide whether the matter constitutes an unlawful discrimination or not. And if it's proven, there is double the compensation. Okay, so that is the difference how far unfair labor practices and unlawful discrimination matters are taken. Okay, what role do you think the government should play in making sure that employees like Sipho and Simon get the same opportunities and benefits in the workplace?
I think better enforcement when it comes to because the act is there, But I think from the government side, what is lacking is the follow through to ensure companies are actually complying. I know that, I know, what do you call it? There's a specific word where it looks like they're complying, but they're not. But anyway, I think there's a loophole. There's so many loopholes currently which are there, and they don't really monitor as much.
Well, the Employment Equity Act, when it takes into account the affirmative action goals, it needs to make sure that there is that representativity in the workplace, right? And they are employment equity affirmative action targets that have to be reached. Okay, so every company needs to have an equity plan in place, especially the larger companies. They must make sure that when you employ people, you must employ them. There must be sufficient people of the various racial groups that make up the workplace. And that there's a commission that oversees that to make sure that the employees comply with that. Okay, so there is that plan in place in terms of the Equity Act that the employees are obliged to file every year, and make sure that they are compliant with the law. But it's a deeper debate. Affirmative action is a necessary thing to address the past wrongs, but for how long will it be in place? So, ideally, in an ideal world, people should not be discriminated against based on their race or their appearance or their religion or the ethnicity or as all those grounds over there. I mean, it says it there clearly. People should be elected simply on the capabilities, on the merits. That is the ideal. Right now, this is limited in our law because of affirmative action. Okay. Are there any further questions or other areas that you guys want me to touch on? I've just been looking. We've covered quite a bit. Just seeing something technical that might come in.
So with the referencing, do they want us to reference each question, or is it like the first or the second assignment?
Fatima, I am not sure. Are you talking about the examination now?
Yes, sir.
You know what? I have not been involved with preparing papers for the exam. I'm not on the exam team or anything like that. So I cannot say, man. But based on how I've now, at other institutions, and now they have been treating students who take assessments home to complete. They are quite strict with
Sir, I can't hear you. Still can't hear you. Nothing.
Anything?
Can hear you now.
Okay. Is it better now?
Yes, sir.
Can you hear me now? Okay, that's good. I mean, I don't know what trouble could be, but okay. So your question was how I would, if I were you, look at very carefully at the instructions that they give you in the assessment itself about the referencing. Okay. So don't make the mistake of not doing referencing. If they're asking you to do referencing, then you do that. Okay, and there's the Harvard method, but I don't know if that's what they, that you could use as reference. But if you make a reference to a textbook, you will cite the author, the publication, the year, and the page number. You can't go wrong with that. Okay, if you visited, you should actually just copy and paste it there as the place that you consulted and the date that you last consulted it.
Okay, thank you.
Sure. Okay. Now, there's one thing I wanted to cover with Adele. Yes.
Yes. Rayan, I just wanted to ask if the students in this session wants a short session on the referencing, I can organize that for them with someone.
Okay.
So they can just let me know in the chat. Okay. I can organize that. When would suit you?
Tomorrow, anytime. I'm free whole day tomorrow.
Okay, during the day, or can it be at 5:30?
Can we at 5:30? Doesn't matter.
Okay. Is your student number in the chat?
Yes, it was the very first one.
The very first one. Okay. I'm going to get back to you. I'm going to see if I can organize somebody that can just sit with you a little and have a session on referencing. Okay.
Thank you so much.
Pleasure.
Cool. You guys can all join there if you like, and that's very helpful. Yeah, the other thing I wanted to cover, which I don't know if we covered this as well, about illegal and foreign workers. What does the law say about that and those categories of workers? And there's also the Employment Services Act dealing with foreign workers. So what does one do? What is an example of an illegal worker? If you're entering into an illegal contract or doing something that the law doesn't recognize as lawful, it would be considered an illegal contract. And under a common law, these contracts could not be enforced. But now there's a very famous case a few years ago, Kylie versus the CCMA. Are we familiar with the Kylie case? Has anybody heard about the Kylie case? Kylie versus CCMA? It's about where this woman took her employer to the CCMA, who dismissed her because she was a prostitute and she had provided services and wasn't being paid, and took this to the CCMA. The CCMA said no, this is, and the common law says that and from an unlawful obligations arise. No obligations arise, and therefore the contract was therefore not, she couldn't be paid. This mattered to the Labour Court, who then applied constitutional principles to it. And said that yes, it is unlawful and the Labour Relations Act to fair labour practices. And the court said that under certain circumstances, probably not all of them, the court will have to look at every case on its merit, but it said that they didn't look at what this woman did, but look at the way that she was treated in this particular facts. And the court said that because of the Constitution, she should be compensated for the unfair way in which she was treated. And the court awarded compensation. Okay. Another case, dealing with illegal work or people falling in the illegal category is the case of Discovery Health versus the CCMA. So in this case, again, what do you do when you employ? You may have heard of people in situations. They particularly look for people who are foreigners and that don't have work permits. Now, what does one do in such a case where you've employed a person from, let's say, Zimbabwe or wherever it is, the UK or wherever, but they don't have a work permit? What are the consequences of that? Do you know? If you employ somebody who doesn't have a work permit, what happens now?
You could potentially ask the person, or well, if they find out, they will send the person back to their home base. Yeah. But I'm not too sure.
Okay, so basically the law prohibits you from, as an employer, to employ people without a valid work permit. You, the employer, will land in trouble because of that, right? And also to some extent, it will also get the employee who doesn't have the permit, like you said, into trouble. But in this case, the court felt, again, using the same logic of the Kylie case, that look, sometimes everybody, irrespective of who they are, if they're in the country, then they're entitled to fair labor practice. And there's a particular law known as the Employment Services Act, which also deals with the question of foreign nationals, people who are not in the country legally, who have done work and have now been threatened not to be paid by the employer. And I've seen this happen many times. In the construction industry, you find people employing people from other countries and not, paying them on the grounds that, well, if you're going to take me to the CCMA, then it will come out that you don't have a work permit and you'll be deported. So there is some truth to that, but it doesn't mean that you as the employer are not able to pay them. You're not allowed to pay them. They can take you to the CCMA on this ground and under this act, and there's the Employment Services Act, which will compel the employer to pay you. Okay. And you would it will not relieve you as the employer from your obligation to pay people who are foreign nationals, even without proper papers, to be paid. So very important that you're aware of that. That might just also come in the paper. Okay, we've dealt with vicarious liability, we've dealt with the restraint of trades, we've dealt with the unfair provisions in the Basic Conditions of Employment Act, what it's trying to do, what you can't do, what you can do under the Basic Conditions of Employment Act. Children are not allowed to work, but there's exceptions, and just be aware of those exceptions. Children under 15, children under 10. You can't really, they are not allowed to be forced to work. They must be of child school leaving age or grade 9. And then even so, if they're under 15, they cannot be given work that is dangerous or harmful to them, physically, mentally, psychologically, in all ways, okay? Children under 10, must the money that's payable to them must be paid to their guardians, and they get extra rest. They can't work longer than 2 hours, then they must be given breaks, and you must provide food and things like that. Okay, we dealt with the Employment Equity Act. There's one thing that perhaps I must cover here, that the Employment Equity Act, like we discussed it earlier this evening, but there's other things that you must also look out for, guys. There's other specific forms of discrimination that is listed in the Act that you might have to know about. I can go over that in the textbook, seeing that we don't have that much time. Harassment, harassment of employees. Remember, I mentioned earlier, harassment is even mentioned under the Employment Equity Act specifically as a ground of discrimination. And it doesn't only apply to women. Of course, mostly it applies to women, but not exclusively to women. And an employer must have a policy in place so that, and the terms of employment should clearly state that, how women must be treated and what is considered unwanted contact or unwanted behavior or unacceptable behavior. And there's an important decision. It's Grobler versus Naspers. Okay, where in addition, if your employer does nothing to stop discrimination, harassment in the workplace, you obviously can you leave because of that. It also ties in with the other form of dismissal known as constructive dismissal, which we dealt with some weeks ago. It's where you leave your employer because the employer has made further work intolerable for you. Okay, and harassment is considered to be intolerable. But so you leave, and you take them to the CCMA on constructive dismissals grounds, and you show, and you prove that why you left was because, not that you wanted to, but because the employer made it impossible for you to continue. And you can get your, damages from them there for compensation. But over and above that, the employer is also liable in delict. Okay, delict means like that civil wrong. When you break the employment contract, these are like basically contractual damages that are calculated according to the laws of employment. But over and above that, an employer who does nothing or, doesn't take steps that are reasonably required, against an employee who is guilty of this kind of behavior in the workplace, then the employer can also be held liable for that behavior. Think about it. If you work for a large company and there's a manager, he's your supervisor, and he harasses you, you can sue the company if you should leave for constructive dismissal. And over and above that, if the company doesn't take your complaints about these things very seriously, and you suffer trauma or you suffer pain and suffering because of it, then the employer can be held liable in delict for that, vicariously liable for that. Another thing also under Employment Equity Act, which you guys can look at, is it's on page 87 of the textbook. Testing of employees, medical testing, psychological testing, and HIV testing. Again, the testing of employees, is not that it is disallowed, but it's permitted only with the employee's permission. Okay, and when it is done, also it must also be done for a particular purpose. It cannot be done, willy-nilly or with some kind of a rational basis behind it. So please look at that. That's on 2-3 pages of the textbook on page 88 and 89. Employment Equity Act, we dealt with that. The affirmative action, unfair labor practices. I think, we dealt with that in quite detail, guys. I may just want to mention over and above the stated grounds of unfair conduct as described in the LRA is also the whistleblowing protected disclosures, that they might raise in the exam. What's a protected disclosure and what's an occupational detriment? And remember, that's to protect you from when you report your employer for something that they're doing illegally. And if you report them, you will get into trouble with them. They may dismiss you, or you would suffer what the Act calls occupational detriment. You'll suffer some kind of prejudice now because you report something that the employer is doing which is illegal. Okay, so if they were to dismiss you and what you disclose does fall in that definition of a protected disclosure, then you would be protected from dismissal. Okay, it constitutes an automatically unfair dismissal as well. All right. Is there anything else? We have 5 minutes left, guys, but if there's anything else, we've covered quite a lot over the few weeks that we've been, we've been having these sessions. You can still, if you want, contact me for a one-on-one session before the exam, before you write, of course. I mean, not if you're writing on the 18th, you cannot contact me then for a one-on-one session for anything that you have difficulty with. But yeah, that is it. I think from your point of view, guys, you should know exactly where to find information, okay, to be successful in this exam, if it's a take-home exam. Seeing that you're not going to be tested in the traditional way, you should at least know exactly where to go find things. And to know how what your textbook looks like, and so that you can have the answers. It would be wise to have a lot of 24 hours is a lot of time, so it shouldn't be a trouble. What do you guys foresee as being a problem in this exam? Do you foresee any problem, first of all?
I feel like they would ask questions like it wouldn't be really clear that, yeah. They would ask a question, but then you wouldn't know like how to basically answer. Like there will be so many answers that you could give. It's just like that fear of like not knowing what exactly they want because, like I said, they won't be clear about it.
Well, look, if I was an examiner and I'm not examining you like I would normally examine you, right, in the classroom and give you a piece of paper with the test questions on it, and you're right, you don't have to give references. And I'm giving you 24 hours to go home and go find answers. Yeah, I won't blame you for thinking, excuse me, I won't blame you for thinking like that. That the questions will be problem type questions, and for you to go find answers. But 24 hours is a lot of times. I think you'll be all right there. And even so, if it were to be a long question, or question that is unclear, you break it up into small parts, and you find the answers to the smaller parts that you've broken it up into, and you can put it together, and then you should be okay. You should be okay, as long as they require references from you as well. So make sure that you just reference and give your references to your answers. Okay, if there's nothing else, guys, then I shall, and I don't hear from you again, then I wish you well for the exam. And if you're going to finish this course and you haven't an LLW2602, then I'll see you then.
Thank you, sir.
Good luck, Fatima. Okay, Queen. Okay. Thanks, guys. I'll see you. Good luck. Bye.
All right. Thank you. Bye.